us for our next edition of our OG Energy Education Series. My name is Patrick Schenkel. I'm a partner in the Houston office of Oliva Gibbs. I manage our transactional practice area at the firm. A little background on me, I'm licensed in 3 states, Texas, Louisiana, Montana, and focus most of my work kind of in Texas and Louisiana. For the topic today, we are going to be covering mergers and acquisitions. The name of this presentation obviously is Yield for Oncoming Merger, What to Watch Out For in Mergers and Acquisitions. This topic kind of came about as we work on many of the things we're going to be covering today on an everyday basis. And so we kind of developed this as a way to kind of share some insights and tips with everyone on what to look out for in these transactions. And just a reminder for everyone as well, right now I would go and download the presentation and the affidavit of attendance and the handout section on your screen. The presentation is going to contain links for them to apply for credit as well. And also we'll send out an email following the presentation with links as well to apply for credit for this presentation. All right, what are we going to be covering today? So topics for discussion. We're going to be going over a letter of intent versus purchase and sale agreement. What is each? What's the major differences between the two? Title due diligence aspects of a purchase and sale agreement. We're mainly going to be focused on the upstream transaction perspective, usually kind of from a buyer's perspective as well on a lot of this, especially when it comes to title due diligence. So the next topic we're covering is preparing for title due diligence. Important considerations to look out for with title due diligence, defect notices, post-closing curative. So first topic we'll get into is a letter of intent, also called an LOI. So what is a letter of intent? The letter of intent often opens the negotiation between the parties. It's going to generally be of limited binding effect. There are some smaller deals that are typically moved forward just on a letter of intent or letter agreement without entering a formal purchase and sale agreement. It's often inadvisable, but we'll be discussing later when that may be a good situation where you may just want to sign and close rather than putting together a purchase and sale agreement with all of your additional provisions. The letter of intent generally is going to set forth the party's expression of intention as of the basic tenets of the proposed transaction. It includes their proposed purchase price, the description of the assets that are getting purchased for that price, an exclusivity period between the parties to negotiate towards kind of a purchase and sale agreement or towards the closure of this transaction, terms of confidentiality, a termination date, and kind of any other provisions you want possibly to include in that letter of intent. A tip here is you may be asked to sign a non-disclosure confidentiality agreement before the letter of intent. So the parties aren't going to want to give you kind of exactly what they own and what they're looking to sell before you kind of sign that non-disclosure confidentiality. So the binding effect of a letter of intent. So this is kind of what we touched on. Letters of intent typically include an agreement that the letter is going to be conditioned on and subject to the execution of a definitive purchase and sale agreement. Again, that's not always the case. There are sign and closes where you may not actually have a purchase and sale agreement and you're going to want to just close on the letter of intent. A sign and close is obviously going to be those situations where there's going to be no due diligence, no period done after you sign that letter of intent. You're going to sign the letter of intent and close on the assets at the same time. Examples of some binding provisions in a letter of intent include exclusivity, sharing of costs and expenses, what governing law is going to apply. It's going to be based off where the assets are, based off of where either the buyer or seller is located, and then obviously confidentiality as well. That's going to be very binding, as we said prior. The one tip we have is you want to be very clear and specific as to what provisions are going to be binding and what provisions are going to be non-binding. As if anyone knows Joe Jamail, there's a very famous case involving, it wasn't really a letter of intent in that situation, it was a memorandum of agreement, but it was a situation where the case is called Tetsuko v. Pennzoil, and it's a situation where Pennzoil was attempting to purchase assets from Getty Oil. They signed a memorandum of agreement to kind of the price they were going to, and agreeing that they were kind of going to work towards a final sale and closure of those assets. Prior to this period ending, Getty ended up selling their assets to Texaco. Pennzoil filed suit. Joe Jamail got hired by Pennzoil in the case. And they filed suit basically saying, hey, we had a definitive agreement with you, a binding agreement to purchase these assets, and then you went and sold them to someone else. And so it's a very, very famous case. The court ended up finding for Pennzoil in that case that there was a binding agreement. So that's why it's very important to be very specific at what provisions are binding, what's non-binding. Is this letter of intent the final stage in the process, or is it just conditioned on working towards a definitive purchase and sale agreement between the parties? Purchase and sale agreement. So we've been discussing this. A purchase and sale agreement is going to define the essential terms and timeline of the transaction. It's going to also, similar to letter of intent, going to include a purchase price, but it's also going to include definitions, adjustments to the purchase price if necessary, any defect notice thresholds, deadlines, warranties, indemnity, many other unique provisions. So the major difference between kind of your letter of intent and your purchase and sale agreement is your letter of intent is generally going to be a 1 or 2 page, just kind of bullet point. Here's the main things we worked on, we've decided on, and we're going to work towards the rest. And then your purchase and sale agreement is going to be your long, if you've ever seen kind of 50, 100 page, all the unique provisions, everything you need between this transaction between the parties that's going to govern everything. The purchase sale agreement is going to be very, very specific terms. All of the essential rights and obligations of the seller and the buyer in the transaction are going to be set forth in this purchase and sale agreement. It's also important to know that although sometimes you may sign a letter of intent to then later sign a purchase and sale agreement, it's also possible to just move forward with the purchase and sale agreement with no letter of intent. And so work towards the parties negotiating based off of just a purchase and sale agreement, and then including all of the terms and red lines and negotiating go back and forth. Also, the actual title of the document may not be a purchase and sale agreement. It may be titled a mineral acquisition agreement, a lease acquisition agreement, an asset purchase agreement. I mean, there's many other variations in the title, but essentially they're all functioning the same. One party is saying that they are purchasing the assets of another says they're selling those assets to that purchaser. And then there's going to be all the terms and provisions necessary to close on that transaction. So the overview of a typical due diligence process. So how we're going to kind of go through the rest of this presentation is how you would kind of structure your due diligence process. And so the first step and kind of what we're going to cover first is pre-execution diligence. So pre-execution, I mean pre-execution of the purchase and sale agreement. Then we're going to touch on definitive documentation provisions and concerns. So this is going to be what provisions are you putting in that purchase and sale agreement that have to do with the title due diligence that you'll be performing. Then we'll talk about a little bit the due diligence periods. This is going to be the time between the PSA getting signed and closing on the assets of when a purchaser will actually go through and do a due diligence and confirm what the seller is selling and whether the seller owns everything that they're repping and warranting to owning. And then the post-closing period. All of this is going to be kind of from an upstream transactional perspective and a lot too from a buyer perspective because, again, the buyer is the one that is normally performing the due diligence in these transactions. Pre-execution due diligence. So, again, this is prior to signing a PSA. A seller is typically going to provide limited title documentation, the form of exhibits and schedules. A lot of this is going to depend too on if this is a marketed or a non-marketed sale, whether the purchaser is submitting an offer blind and kind of cold, or whether this is through a marketed deal where someone's been looking to sell this assets and has put a package together to sell. And so there's going to be kind of this limited title documentation. Hey, this is what we're claiming to own. This is what our leases, wells, everything we're claiming to own. And this is going to be obviously to help the purchaser put together a purchase price on how to value that and to work towards kind of a definitive purchase or bid on the assets. What the seller would typically not provide is going to be backup title documentation to facilitate a pre-signing review of title. So it is not in the seller's best interest to provide all their title on how they reach those numbers, how they own that interest. The reason for this is they don't want to provide a title. Pre-signing is to limit the period of time during which the purchaser can actually find defects. And so you don't want to allow the purchaser to have an extended runway of time to review everything, be able to poke holes in all the interests that they own, find any defects, lower purchase price unnecessarily. They also may do this to prevent discoveries that could lead to changes to the unsigned PSA or delay its signing. So obviously the goal here is you want to work towards signing the PSA and then kind of perform a due diligence and close on these assets. Like every purchaser and the seller here are both looking to facilitate this transaction. And so if you're providing more information ahead of time, even before purchase price is agreed to, before PSA has been signed, then it's just going to push everything out further because the purchaser is going to want to look through everything, discover if there's any issues, keep going back on the negotiating table. And the last reason is maximum confidentiality, should the deal never be signed. And so they don't want to provide you with all of their documentation, all their private files, all of their confidential files, if there is never going to be a PSA that's actually signed on this transaction. They want to have maximum negotiating power from a seller perspective here. So also with regards to pre-execution due diligence, like I said, this does not mean that a purchaser should not conduct pre-signing diligence. It's generally advisable as a purchaser, you want to get a general level of comfort with the proposed lease and well exhibits. You want to make sure that what you're purchasing or what you're negotiating to purchase, that they actually own something, and that you have some level of comfort in that. To assess and kind of allocate value, a purchaser would generally confirm that the proposed exhibits tied to kind of the internal geo models, projections, everything else internally that the purchaser may put together when putting together their bid on the assets. Also, even though we're talking about general level, depending on the purchaser's analysis as to the probability that the deal will be signed. So if you feel pretty confident that you're going to get a PSA signed, it's good this is going to happen, it'd generally be advisable in those situations to, as a purchaser, to begin discreetly reviewing record title, lining up your brokers and your attorneys to begin their work. Really, you can start reviewing prior to that due diligence period. Obviously, you're not going to have the seller's files at that time. They're not going to open up their data room or provide you with all their title opinions or provide you with all their information. But that does not mean you can't go to state, federal, county records, begin reviewing, confirming, and kind of performing some of this pre-execution due diligence. Some tips we have is to hire your broker and title law firm, have them lined up as early as possible in the process. You want to make sure that there's no conflicts. You want to make sure that both the broker and the title firm have capacity to take on as necessary. You want to make sure that there's fair warning about kind of the expected maybe due diligence period, what you're looking to purchase, where these assets are located. It's also important to know kind of what you're looking to acquire. Do you need federal records with your due diligence, state records? It may take a lot of time to get some of those records, especially from a federal perspective. There's a bit of a holdup on trying to get federal records. And so sometimes you may want to order those prior to the PSA being signed, just because of the length of time it's going to take to get some of these records to review. Or else, if you do not get them, sometimes you will be buying the assets without a proper kind of due diligence. And like I said, you want to understand where and how records are stored before the beginning of the due diligence period. It's also important to know kind of what type of records does the seller likely have on the assets. What is the seller like? This is where you kind of want to think bigger of how trusting you are of the seller, whether you think they have good records, whether you think that they are a good operator, whether they have reviewed everything themselves. You really want to start thinking in depth of what you will be provided when you sign the PSA from the data room, and whether there are going to be any skeletons hiding anywhere in there that you're going to want to look to find. So the title due diligence aspects of the PSA. So obviously within a PSA, like we said, it can range anywhere from, you could have a couple page PSA to a 100-page PSA. Title matters are likely going to be addressed in several different sections. Some of those sections are kind of your reps and warranties, conditions to close, indemnification, and title defect mechanic provisions. So we're not going to touch on everything as time permitted. We won't have time to touch on kind of every single provision, kind of having to deal with title matters, but we're going to touch on a few of the provisions today. We have those kind of listed there. We're going to go over kind of definitions for a lot of these provisions. So what is the definition for defensible title, marketable title, title defect, title benefit, permitted encumbrances? What are some title defect limitations that may or may not be included in a PSA? How do you define the title diligence period, title defect notices, and then some title defect remedies? So sell or cured, if there's any curative, how is it remedies to cure some of those defects? And then title defect disputes. If the purchaser and seller cannot agree on either the title defects being claimed or curative, kind of how do you move forward? So first, we're going to touch on kind of defensible title. So defensible title means that the seller has kind of record title of the assets. Typical definition of defensible title requires that the seller have title either deducible of record or evidence by documentation that will make title likely to be successfully challenged. The defensive title is typically subject to a negotiated list of permitted encumbrances, which we'll touch on later. Given that a purchaser's title protections are generally limited to the interim period and it's clearly defined in the PSA, obviously it's going to be important that you fully analyze and understand these title provisions. And one of these, as we're covering here, is defensible title, which is very important as a starting point as to kind of what title is the seller confirming that they own. Is it defensible? So as we all know, title to oil and gas interests can sometimes be very complex and difficult to verify through a review of publicly recorded and unrecorded instruments. And most PSAs, the seller is going to represent that as good title to the assets. However, because of the complexity, the seller might not want to rep that they have marketable title. And so that's where we're going to touch on the differences between what is defensible versus marketable. Marketable is generally going to be at a higher standard. And so generally, the seller is not going to rep to this marketable title. The runner is going to rep to defensible title, which is going to have a slightly lesser standard. And generally, sometimes too, you will see in a PSA that there'll be a specific statement that the parties do not intend defensible title to mean marketable title. Further, even marketable title in some states is going to have a definition, be that in kind of title standards or somewhere else. It's going to have a definition of what is marketable title. The reason, again, people use defensible title is there's no legally or commonly accepted meaning for defensible title. So it's going to have to be defined between the parties in the PSA. It's going to be a term that's going to be negotiated on between both parties of how they want to define defensible title. So it's going to be very important to clearly define this applicable standard. And so in that regards, I have here kind of a defensible title example provision. So here, defensible title means the right title and interest held by the seller that will entitle buyer to receive not less than the net revenue interest described in the Exhibit A. It's going to obligate buyer as such as the percentage of cost. Most important here is that it's Part 3. Defensible title means that the seller is kind of saying that their interest is free of all liens, security interest, encumbrances, and defects. And this is kind of what we touched on a little bit, except for permitted encumbrances. So this is going to be a common example of defensible title example provision that is commonly seen. Another example of a provision that you'll see with regards to defensible title may have some limitations in there as well. And so I wanted to include one that shows kind of what a defensible title limitation means. And so in this one, the assets that are being sold by seller, they're only selling basically, or they may be selling more than, and limiting kind of the defensible title standard to just the Barnett formation. So it's possible that they could be selling all formations and all depths, but they only want to say that we are repping that we have defensible title to just a certain formation. That's always possible. Or it's possible in this one that the parties were saying we're only conveying the Barnett formation. They're only repping as to during the productive life of the working interest, lease, or wells. And they're also saying that it's deducible of record or evidence by documentation, which although not constituting a perfect marketable title, it's probably a successfully defended challenge. So here's that provision I was talking about where they're saying we're not repping to marketable title. Defensible title is something totally different than marketable title, in kind of a lesser standard. So I know we've talked about marketable title a bunch, and how marketable title standard is going to be difficult to achieve a lot of times in oil and gas title. And thus the seller will want to ensure that definition of defensible title is used in the PSA, and that defensible title is clearly defined and achievable standard. However, that doesn't mean that marketable title doesn't exist in PSAs. Sometimes deals will move forward based off marketable title. And so what we have included here is kind of the marketable title definition in Texas. Marketable title in Texas is free from reasonable doubt as to laws of matter and fact, not supposed to purchaser to probability of litigation, free from any liens, mortgages, anything else that would form a basis for litigation, does not depend on estoppel or presumptions or extrinsic evidence, parole evidence, something outside the record in order to confirm title, and is something that a prudent person advised on the facts and the legal significance would be willing to accept. So as you can see, this is a much higher standard than what we said previously on our defensible title. So this is like you are 100% sure this is kind of the interest we own. And you can see why a seller would not want to use a marketable title as a definition. It would rather use this kind of lesser standard of defensible title. The Texas title standards also list 7 matters that may make title unmarketable. I kind of wanted to provide examples of those. So some of those include land acquired by limitation title. So if you're using acquisitive or adverse possession to acquire title by limitation title, that's going to make title unmarketable. Land acquired by accretion, so kind of movements of bodies of water, erosion, things like that. Title that's subject to outstanding oil and gas leases, title that's subject to outstanding royalty interest, title that's subject to outstanding covenants, Title subject to outstanding easements, liens, mortgages, judgment liens. All this is going to make title unmarketable according to the Texas title standards. And if you're using that marketable title definition, then those Texas title standard comments are going to be very applicable, because if that is the standard that's being used in the PSA of marketable, then all of these this title standards are claiming would make title unmarketable, and therefore you would be able to claim those as defects. So what is a title defect? A title defect is going to also, similar to defensible title, be a defined term in a PSA. Typically going to encompass a condition existing on kind of the assets you're looking to buy that causes the seller to not have defensible title. So this is a title defect is going to be something that you find in their title that renders their title to not be defensible. Or it's going to be something that causes a decrease in kind of the interest that's represented by the seller within the PSAs, be that net acres, net revenue interest, something along those likes. So whatever the asset that is that's being sold, a title defect is going to cause them to have a lesser interest than what they've rep to. Obviously, a title defect is going to be something that's discovered in the course of a purchaser's due diligence. So things kind of found before the PSA signed or after closing, they're not going to be necessarily referred to as a title defect. So what the title defect is going to be those things that are going to be found, brought forward to the seller during the due diligence period. And as we've mentioned, kind of with defensible title, it's also very important to pay close attention to what the seller defines as a title defect under the terms of the PSA. From a purchaser perspective, this would often be a red flag as to what defects the seller is aware of, is in attempting to expressly limit. And so this may be them kind of highlighting where they think there are some skeletons that they don't want you to find. And so it's very important to kind of pay close attention to that and use that as a negotiating when you're doing this, and also think of that from your pre-execution diligence as well. Kind of maybe if they are limiting this in any way, maybe this is something we want to go make sure we double check on before we sign this PSA. The title defect example provision. So here's an example, a very quick and easy one. Again, these can be written in many different ways, but here's just a quick and easy one. Title defect means any encumbrance, irregularity, or defect in seller's title to which an interest, a loan, or in combination with other defects causes seller title to be less than defensible. That defensible title, obviously being a capitalized term, is going to be defined elsewhere in the PSA, and so that's also going to be negotiated on as well. In addition to title defects, there may be also a definition for title benefits within the PSA. So obviously a title defect is going to be anything that lowers the seller's interest or causes them to have less than defensible title in the interest that they're claiming to own. Title benefit is obviously going to be the opposite. It's going to be where it's found during the due diligence process that the seller actually owns more than they're claiming to own. And so obviously that from a seller's perspective, they want to include a contractual provision in the PSA where, hey, if during due diligence you find that we own a greater interest than we rep to own, we want to be paid for this greater interest, or have a provision representing kind of what this greater interest may represent. And so title benefits can be negotiated against. They can be limited. They can also just not be included if you don't want to include them. From a purchaser perspective, title benefits can be dangerous because you don't want to sign an agreement that you've placed a bid on this assets and think you're paying X, and now the payment price has increased to Y because you found that the purchaser or the seller actually owns a greater interest. And now you may not have a capital close, you may not get more financing. It can be very dangerous, a title benefit. And so what you generally want to do with the title benefit is you can negotiate on what a title benefit will actually be applied to. So you can say, yeah, we agree there may be title benefits, but there can be no upward purchase price adjustment as a result of those title benefits. However, the purchaser can use, or the seller can use those title benefits maybe as an offset against any title defects. So if, say, we've had a $5 million title defect on the assets that they're looking to sell, but then on another tract, we found a $3 million title benefit, you can put in there that, hey, that title benefit can be an offset against that title defect. And so now I can only claim the purchase price can only adjust it down, maybe that $2 million difference. Also, it's important to think whether title benefits, which we'll be discussing later with regards to title defects as well, but whether they should be subject to thresholds and deductibles. So whether they should be kind of limited in any way. And it's also important to consider handle additional leases located within a specified area. So this would be if you're making your valuations and everything on a lease basis and you find a bunch of additional interest and a bunch of additional leases within the specified area that's supposedly getting assigned, how is that supposed to be accounted for? Are those technically title benefits? How that's supposed to occur? So all this can be negotiated on and limited in any way within a PSA. There's no set standard on necessarily how this has to be set forth. So we've discussed permitted encumbrances a lot with regards to defensible title, also with regards to title defects. So permitted encumbrances are often incorporated into the definition of defensible title, as we kind of saw some of those defensible title example provisions that I shared. Permitted encumbrance, so what is it? It's going to be a defect in title that the parties know about or possibly are looking to cover prior to kind of execution of the PSA. And it's going to be expressly carved out for the definition of title defects, and thus the seller will not provide any remedies if there are defects that are found with that permitted encumbrance. So essentially, it is something that the purchaser is allowing to be permitted as a defect that will have no effect on the purchase price or their ability to claim defects on it. A couple examples of some permitted encumbrance provisions will often include things like landowner royalties, production payments, overrides, any type of reversionary interest. So if there is kind of a right of first refusal, or if it's a term assignment and there's a reversion on it, there may be a provision for an encumbrance provision addressing that. Sales contracts, liens, easements. With the other kind of two definitions, title defects and defensible title, it's also very important to pay close attention to what the seller defines as permitted encumbrance. I think this one may be the most important, as this is going to really tell you as to what the seller is aware of and what they're trying to expressly limit, where there may be red flags, where there may be skeletons. This is where you're really going to want to be on the lookout for what they are trying to limit the defect coverage from. So with types of permanent encumbrances, so we went over kind of a couple. Here's a few more specifics. Again, permanent encumbrances are going to be heavily negotiated. This is one of the most heavily negotiated parts of a PSA from the title diligence aspects. So some others that may be included are application of Marketable Title Acts, whether you allow permitted gaps in production with regards to leases. This is going to be very important and one that should be very closely analyzed, dealing with kind of this permitted gap in production or cessation of production. Sometimes the provisions may say that you may allow a gap in production of a few months or for a certain period of time, and these leases still may be held. However, that isn't taking into account what the lease provisions actually say, and so you want to make sure you're thinking very closely about how that provision is drafted, how it reads, whether you want to include that based off the assets you're looking to buy. Some other provisions may be permitted lessor mortgages, liens, defects cured by laws of prescription, so limitations, title type issues, de minimis defects, so like very, very small, kind of nickel and dime, very tiny defects. Those may be kind of permitted. Common liens, easements, government approvals. Another key permitted encumbrance to read closely is, if proposed by a seller, is a customary rights of reassignment, whether they have a reassignment right. This permitted encumbrance may have a large impact on a purchaser's ability to assert a title defect, as is intended to include kind of all interests that have been reassigned, possibly under even like a Pew clause. That's where it's also important to think about what permitted encumbrances. If you have a lease with a bunch of leases within their primary terms, you want to be thinking about how a Pew clause is going to operate with regards to those leases, whether you actually be able to claim defects on kind of interests that may be pewing out very quickly after the deal's closed, whereby you would, as a purchaser, have any ability to hold on to more acreage. You want to be thinking about that, negotiating, make sure that you're possibly able to claim defects on some of those where there's no recourse around losing that acreage and you're not paying for things that you are really not getting fully rates of. Tip, be aware of provisions related to, as we said, terminated leases as to lands or depths, required consents to assign, reversionary interest, area of interest agreements, preferential rights, additional contracts such as gathering, transporting gas. Just a handy tip there. Permitted coverage and sample provisions. So these provisions are normally fairly long, so I've broken this one out into kind of two different slides. And also what I've included here is generally a buyer-friendly provision that you would think of. The buyer-friendly one is going to be kind of more open-ended. It's going to have less bite, kind of less, you'll be able to claim defect on more things under obviously a buyer-friendly one. And so this is kind of how it's going to read. Permitted encumbrance with respect to sellers and property shall mean the following, and kind of set forth all the different provisions in here. And so if you find a defect in regards to any of these four listed here, you will not be able to claim them as a title defect under the PSA. So these, again, permanent encumbrances are things that you are permitting, encumbering kind of the assets that you're looking to purchase. Here's the kind of, I said I broke that one out into two. Here's the second portion with the 5 additional provisions. Important here, I'll note the kind of H and I. So H is going to be agreements set forth on kind of attached exhibits. So that's going to be anything that may be reserved or not included in the transaction, or anything within different schedules that they're saying, hey, look, we're informing you of this ahead of time. We have an agreement that kind of both parties are informed that this is an issue and you won't be claiming a defect with regards to it. And then with I, title defects waived by buyer pursuant to the terms of this agreement. So this is essentially saying that, hey, if you don't bring up a title defect, you're waiving all rights to any title defects pursuant to the terms of the agreement. So you can't just come back later and say there was a defect if you didn't bring it up during the terms of the agreement. So I know this one, like I said, is a buyer-friendly provision. So I thought I would show you what a seller provision looks like as well, and kind of major differences. I would take a look here at H and I as well, similar to how we looked at H and the other ones. As you can see, this one says that permanent encumbrances shall include defects or irregularities resulting from or related to probate proceedings, which defects or irregularities have been outstanding for 5 years or more. So essentially saying, hey, if you find an issue with a probate from 6, 7, 40 years ago that is affecting title and would allow the seller to have less than defensible title in the assets they're looking to purchase, you can't claim a title defect in it. You're essentially limited to only bringing up title defects that have been outstanding less than 5 years with regards to probate proceedings. And then here's another one with regards to cessation of production. I know I've talked about that. Cessation gaps and how important those are with regards to permanent encumbrances. So this one essentially says that anything occurring prior to any gaps, cessation of productions, insufficient production, so like not payment or no production and paying quantities, any of those occurring prior to January 1st, 2000, can claim a defect on. So if you find a large gap in production over a couple years on a well that you're looking to purchase, or at least you're looking to purchase, and you think that that lease is no longer valid, you will not be able to claim a title defect on it because that gap occurred prior to January 1st, 2000. And so this is kind of, we went both ends of the spectrum here, like I said, a seller provision, a purchaser provision, but this is kind of a strict written seller provision. It kind of shows you too maybe where the seller may think there's some skeleton hidden so they don't want you to find and claim defects on. Title defect limitations. Talked about a lot of title defects. Sometimes there may be limitations in how much title defects you can claim, or there may be or not limitations in how much you can claim, a threshold into what you have to reach in order to actually get a title defect, or a deductible that you need to reach in order to actually begin to lower the purchase price. And so in most cases, purchase price adjustments for title defects are subject to these, like I said, deductibles or thresholds. Either of them may be stated as actual dollar amounts or as a percentage of the purchase price. The reason for these provisions is essentially the seller wants the purchaser to have some skin in the game prior to actually getting a purchase price reduction. And so a threshold you can typically think of as kind of your minimum defect needed on an individual well or lease basis in order to claim kind of a defect on that asset. So thresholds only allow for a full adjustment after that threshold is met. And so these are generally a dollar amount. It's generally what you see with these. And they're going to be very important to set that dollar amount based off of kind of the nature of the assets that are getting purchased. And so if you're purchasing a bunch of small leases with equal value, then you're not going to want to set this value too high because you want to make sure that you can claim defects on a lot of the small leases that you're looking to purchase. On the other hand, if you're just buying a large concentration of value in a few specific wells or leases, so say you're buying 5 leases and they all have a large value and buying some same in the wells, you may want to set this value a little bit higher to account for the higher valuation of those assets that you're looking to purchase. So I typically think of thresholds as kind of I'd call it like a penny defect. It's like kind of, we're going to make sure you're not taking out all the little like $1,000 defect here, $1,000 defect here against the seller. That doesn't really make a meaningful difference. And again, that's skin in the game argument that the purchaser should have some skin in the game in this prior to actually getting a purchase price reduction. Deductibles, on the other hand, so deductibles are going to be what your full defect value is going to need to reach before you can actually get a purchase price adjustment. Deductibles limit purchase price adjustment to one of those amounts exceeding kind of an agreed amount. And so generally, these are going to be reflective of the size of the deal. And so you may see an example is like a 2% of the unadjusted purchase price. So this is saying that, hey, you may have to reach a threshold of maybe $10,000 per lease to get a defect value above $10,000 to claim an actual defect. And then what this is saying is that all of those 10,000s or more added up need to total 2% of the purchase price before you can actually start getting a purchase price reduction on the transaction. It's also typical you may see a provision in there that the deductible is not a tipping basket. And so by that, it's saying that, so it may not be that you need to fill this bucket enough to reach a certain amount to get any defect, but it may be saying that you may need to fill this bucket enough in order to claim a certain defect. So say, for example, the deductible's $10 million and you find $12 million worth of defects, and the no tipping basket idea, you would only be able to claim a defect on that $2 million difference between the defects found and the deductible, rather than the full $12 million that's up. It's also important to pay close attention to the respective allocated value of the leases, ensure that the threshold does not effectively exclude your ability as a purchaser to exclude or to assert any defects on those. So you don't want to make that threshold value higher than kind of the valuation on an individual lease basis, because then you won't be able to claim any defects, even if you found a bunch of bad leases. Unlike the threshold, typically the purchaser is only entitled to a remedy for defects above the deductible. So that's what we've talked about, that excluding the amounts below the deductible, the kind of that tipping basket argument. So here's an example provision, typical kind of title defect limitation example provision. As you can see in here, in the middle, there's the does not exceed 100,000. That's your individual title defect threshold amount that's going to need to be reached in order to claim a single defect on any one asset. And then at the bottom here, you see that aggregate deductible is going to be that full kind of deductible amount you have to reach in order to claim a purchase price adjustment. Some common questions regarding title defect limitations. So again, like we said, what are your defect thresholds? Defect deductible amounts, are you thinking about those in regards to the assets you're looking to buy? Also, it's important to look at how are the assets being valued. So where's the valuation set forth on them? Are you allowed to use defects cumulatively or in the aggregate across wells or DSUs? That's also very important. Or will each defect have to individually meet the threshold? So this idea of if you're evaluating on a well basis, will every single little defect we find across the board be able to be aggregated in order to claim one big defect on that well, on that valuation, or will that threshold need to individually meet the amount? So all those little stuff that you have found, do those all individually have to meet the threshold, or is the cumulative amount enough? Like I said, be sure that to get thresholds and defect deductibles reflect the type of assets being acquired. All of this can be negotiated. It's also important to understand with regards to these two, what the negotiated threshold amount triggers a walk rate. So a walk rate is going to be, if there are defects up to a certain amount, then the parties may get to exit the transaction. It's also important to know who does the walk rate apply to. So sometimes it may only apply to the buyer. With regards to a walk rate, if they find defects above a certain amount. It's also important to know from a purchaser perspective too, if it does apply to the seller, do they have an immediate right to terminate the PSA? So are you, in a sense, by claiming a defects above a certain amount, harming the ability for this transaction to actually close by giving the seller an automatic right to terminate? It's also important to know, can the buyer waive or withdraw defects if the seller lets to terminate? So again, that idea of, hey, we're going to claim defects above this amount, but we're going to withdraw some to make sure it's below that to not allow the seller to terminate this agreement. Title diligence period. So this is kind of self-explanatory. Title diligence period is going to be that time from the execution date of the agreement through the defect claim date. So the defect claim date is going to be the date when you need to file all of your defect notices to claim a title defect. Generally, how these provisions are going to be written is that any title defects filed after the defect claim date, you're not going to be able to claim a defect on. So you're not going to be able to get a purchase price reduction unless you file your defect notices during this kind of title diligence period. During that period, I'll typically provide in the PSA that the seller will agree to provide purchaser and its representatives access to their records, maybe access to any personnel familiar with the assets to ask questions. They're going to open up the data room. They're going to provide you with everything that they possibly have, allow you to kind of dig into their records, ask questions. A typical due diligence period that you'll see within the PSA is going to be probably either 30 to 60 days. It can always be negotiated differently. And it's very much going to vary depending on the size of the transaction, the scope, what's being acquired, time constraints of the deal, all the parties looking to close kind of prior to the end of the year for tax reasons, what's the time constraint on it. It's important to know that obviously from this perspective, a purchaser, as long as time constraints of an essence, is going to look to make this due diligence period as long as possible. You want to afford yourself the longest opportunity to review everything, to get comfort with everything you're buying, and you also be able to find defects to lower the purchase price. And from a seller perspective, they are not going to want you to have just an unlimited runway to review everything and be able to nickel and dime and be able to find any defects. They want to limit this as much as possible. And so it's important to think about that when you're negotiating this due diligence period. And it's also important to negotiate thinking of both parties are working to close this transaction. They're both one's looking to sell their assets, one's looking to purchase those. I mean, they both want to go through with this transaction. So let's try to make this as easy as possible for both parties to do that, to reach that close date and to reach this actual conveyance. You'll generally see sometimes within these title diligence, the defect claim date, kind of within the PSA, that the seller will require periodic preliminary updates of potential title defects. The reason for this is the seller doesn't want to be bombarded on the defect claim date with hundreds of title defects that they need to go through now. And so they'll generally want, hey, just keep us afloat of what's going on and please submit these title defects on a rolling basis up until the defect claim date. From a purchaser perspective, obviously, as I said, you want to give yourself as much time as possible for due diligence as the seller agreed to. It's also important to remember, too, that you want to keep in mind give your broker sufficient time to run the title and the law firm sufficient time to review the title and identify defects. You want to give kind of your third parties enough opportunity here to actually do their work and be able to perform due diligence as best as possible. It's also important to bear in mind that due diligence review is not full title review. So due diligence review is going to be based off of kind of a limited record title, generally limited to kind of what the seller is actually selling. You're going to just limit it to the seller's interest, maybe limited in scope, maybe limited in time period. You're going to want to limit this in order to afford you the best opportunity to perform due diligence on the most assets possible. It's also important to know that within the title diligence, sometimes too, you're going to want to have to make hard decisions about what you're actually going to have time to review and what you're not. It's very, very typical that you are not going to have time to perform diligence on every asset you're looking to purchase. And so many buyers kind of use an economic evaluation to try to determine what to run diligence on. It's commonly referred to as the 20/80 rule. It means that 20% of the properties being purchased in the aggregate generally may constitute 80% of the value of the properties being acquired. And so you want to make sure that you are performing proper due diligence on those assets, because those are going to be, if they're constituting that 80% of the value, those are going to be the most important. It's also important to communicate the time period, this title diligence period, as soon as possible with your attorney and brokers. Let them know the dates, let them know how feasible it is, let them know what they may be able to get done within that period of time, and whether that works from a diligence perspective for you as a purchaser. It's helpful always to have those dates ahead of time, which are required for completion. You want to make sure that all the broker work and all those legal services can be completed prior to that kind of defect notice date. And also, as we said, we recommend you usually create a priority list for the assets, starting with the highest value first, kind of going from there as you're trying to set forth kind of what you're going to perform diligence on. Title defect notices. Once the scope of title defect is defined and agreed to, it's also important to find what notice is required for title defect to be valid. So what type of notice do you need to bring forward? Typically, a title defect notice provision provides that the purchaser's failure to give notice of a title defect within the time and manner specified shall be a waiver by the purchaser of that title defect. That's a very important provision that's usually intended. The one most important thing to kind of look out for with regards to title defect notices is, do you need to verify a defect, or do you need to identify the defect based off of the supporting documentation that you're providing and the defect notice that you're submitting? So the difference in being, if there's a gap, there may not be as much supporting documentation to support the gap and the reason for the gap, and so you would just be verifying that there is a defect. First, if you're identifying a defect, you may have to identify the reason for a defect, and that's going to be much more difficult for a purchaser when trying to claim defect notices. So it's important to know how this provision is written, what type of supporting documentation and what type of notice rationale for the defect you need to provide to the seller. So I've included here a title defect example. These, again, can be short and sweet, just like this. So for the short description of the title defect, what's the affected property, based off of kind of what's in the exhibits, what assets are getting sold, how you define the property, the allocated value of that property, any supporting documentation, any documents, any information that's needed to back up why this defect's being claimed, why this is a defect, and then a purchase price reduction. So how does that defect affect the purchase price? And it's also important to know that, again, you don't want to file these defects if they're below a threshold. So again, if that purchase price reduction is below that threshold amount, you're not going to be able to claim a defect, so you won't want to file these. So keep that in mind when you're going through and filling these out and putting these together to send to the seller. Some examples of some title defects that you may send would be kind of interest owned by a third party instead of owned by the seller, lease expiration or releases of leases, unreleased liens on the interest, gap in chain of title, unrecorded documents affecting title. They don't own the interest in the target depths, or not all. They don't own all the interest in the full targeted depths. Maybe possibly lack of production, any after payout adjustments. These are just some examples. Title defect remedies. So typically a seller will want to control the ability to elect whether to cure a defect or kind of any other remedies available to them. So some adjustments of some other remedies if the seller is like, hey, we aren't curing anything. They may include that, hey, if you file a defect, then we'll adjust the purchase price. We may say, make a decision based off of the defects you're claiming, whether we just want to exclude those properties from the transaction. So in a sense, adjusting the purchase price as well, but adjusting what you're actually getting and acquiring as a purchaser. Or just allow some type of indemnification to take hold with regards to those defects being claimed. The purchaser is going to want the ability to confirm whether the remedy actually cures the title defects. So generally, as a purchaser, you want to make sure that the seller is actually curing it. So you want to make sure there's some provision in there saying, hey, this is curing it to our satisfaction. Yes, this does cure it. Rather than the seller thinking they've cured it, submitted it, and saying, hey, there's no longer a title defect here, when whatever type of curative action they've taken doesn't actually cure the underlying title defect issue that's been claimed. But it's also important to know that for title defects, a seller would typically have a post-closing cure period. So they're not having to cure all of this necessarily prior to closing. So there's going to be a period kind of post-closing where the seller can go back and cure these interests. And during that post-closing period, it's all going to be negotiated whether the assets that are subject to these defects are being conveyed to the purchaser's amount held in escrow, whether these assets are being retained by the seller until they've cured it, kind of how the process is going to work with regards to curing these and getting these actually conveyed over and paid for by the purchaser. Title disputes. The PSA will usually require parties to mutually agree on a way to use the reasonable efforts to agree on title defects and amounts prior to closing. So agree, hey, this is a title defect. This is a title defect as to this amount. This is going to lower the purchase price this amount. Agree on what is a title defect, what's being claimed. However, always between parties, when you're dealing with multiple different parties, there may be disagreements over what is a title defect. Hey, what is the actual title defect amount that should be claimed here? You'll generally see provisions saying that parties should use a reasonable efforts to agree on all of this information. However, parties may not always agree. So in that case, if they do not agree, if agreement cannot be reached on a title dispute, either party, generally under a PSA provision, will be able to elect for arbitration, typically by a title specialist. It's important for these provisions that, as written, that arbitration shouldn't delay closing in any way. So you don't want this arbitration to hold up your ability to close on the assets. Valuations and PSA. So obviously this is very important. How are you setting forward the assets and evaluating them? Are evaluations being done as different benchmarks? Are evaluations being made subject to certain carry agreements and or before or after various payout thresholds? Which payout threshold is actually being used in the valuation? Are title defect provisions consistent with the interest described on the PSA exhibit? So all these provisions we've kind of gone over, are they consistent with what's actually in the PSA exhibit? So very important to look over these as well. How are you evaluating it? And how does that work with the rest of the provisions within the PSA? So obviously then after you have signed the PSA, you work through your land due diligence. And so here we just have a bunch of examples of things to kind of be on the lookout for from a due diligence perspective. You generally want to think about these things ahead of time. Maybe prepare a checklist of, hey, here's all the things we want to check through. Make sure you know who's these obligation to actually check on this stuff is delegated out to, be that a broker, a law firm, in-house, who is going to actually check on all of these things. And we got just a handy list here. If you download the handout, you'll be able to go back and look over these. These will be very helpful. And one of the ones I would note on here is that define the internal due diligence team for the acquisition. And so as a purchaser, you want to make sure that you know who is performing the due diligence here, who's in charge of this, and have a good idea too when you are setting forth that team that you're mindful of the integration of the asset. So every guys, you're going to integrate this into your company, who's going to be kind of heading up this asset going forward. Probably be a good idea to put that person on the internal due diligence team to make sure that they have familiarity when they actually do kind of begin their supervising of that asset. Some tips with regards to land due diligence: confirm whether the seller is willing to share files, or if you'll just be limited to a virtual data room, or kind of how the seller is going to share their files in the situation. Another tip: in some instances, it made sense to render defect notices without acquisition title opinions. So you have to make the decision ahead of time. Do we need opinions here? Do we not need opinions? How do we want to move forward on this? Acquisition opinions are obviously going to be very helpful to identify defects that can impede a future sale of the asset. So acquisition title opinions are going to possibly show you kind of, hey, here's where defects could have been claimed if not for that permitted encumbrance. So we have a good idea on a future sale of the asset, kind of what defects exist with regards to what you're buying. Also, acquisition title opinions could be required by your lender. So generally, lenders may require acquisition opinions on assets covering at least 80% of the purchase price or a certain threshold. The lender will want to see that there has been an attorney that says the seller does own a certain percentage of the assets that you're looking to purchase. Some more tips, due to time constraints, every discussion we want to allocate time based on comparable value of each asset. So don't want to spend time on the low value assets. You want to make sure that you are spending your time performing due diligence on the high value stuff that you're looking to purchase, because that's the most meaningful asset. Consider threshold requirement for preparation of an acquisition title opinion. Again, it may not be cost effective or impossible to obtain title opinions on everything, and acquisition opinions will typically be limited to the interest being acquired. So obviously limited to what the seller owns and what the seller is claiming to sell. Defect notices, who will be preparing defect notices, all of that information. Again, all of this is going to be available on the slide. I know we're buttoned up against time here, so we'll kind of move forward with a lot of this. So again, evaluating defect notices, how are you going to value them? Make sure you're being not being too cooperative from a purchaser's perspective. You want to make sure that your brokers and lawyers aren't helping to cure the seller's title ahead of time. You want to make sure that you're putting that onus on the seller to actually cure this stuff, and you're just claiming a defect and just pointing out where the title defects are. Narrative is going to be important when filling the defect notices out. You only get the one opportunity to explain what the defect is that you're claiming, so make sure that you are being very clear and that the seller, any other one else, can easily ascertain what type of defect you're claiming and what that defect is. And then also just submit your defect notices on a rolling manner. Obviously, this is helpful for everyone, and the seller will appreciate if you submit them on a rolling manner. We will then jump ahead to continuing education credit for attending the webinar. So obviously, this webinar, we've gotten approved for many different credits here. And so we're pending credits still in Ohio and Texas, but we have it approved for CLE credit, Oncoming, Louisiana, and then all of your landman credit. For any accreditation questions, obviously you can reach out to us at the firm at any time. There's an email address here available for you. And also, if you want to apply for your own credit, here's how you will do that. Please note a follow-up email with all credit information and the recording link was sent to you early next week, so you'll receive that. However, in the meantime, again, I'll remind you to download the attendance affidavit and the presentation now, so that you have those if you want to claim your own credit, because this will give you immediate access to their APL credit, all the links that you need. If you're unable to download the file, don't know how, we'll send a follow-up email with that information and the recording link early next week. So that's going to be it for my presentation today. I want to thank you all for attending. Again, my name is Patrick Schenkel, partner here at Oliva Gibbs. If you have any questions, feel free to reach out to me at the phone number and email listed there. Also, if you download these slides, you can happily click on the link on my name that will pull up a bio. And here's just a little more information on our firm, kind of what we do with regards to due diligence and the oil and gas and mineral transactions. So again, thank you all for attending. I hope everyone has a great rest of the day.